This is attorney Adam Sherwin of the Sherwin Law Firm. My website is www.sherwinlawfirm.com. I'm a Massachusetts foreclosure defense attorney. And I wanted to speak to you a little bit today about the Massachusetts Foreclosure Title Clearing Bill, which Governor Baker signed into law several weeks ago. This presentation is only for informational purposes. It isn't legal advice, and you should absolutely speak to an attorney before making any legal decisions on this matter. The Massachusetts Foreclosure Title Bill largely came as a result of the SJC's Ibanez decision, which came out a number of years ago, which was the first wave of recent foreclosure defense decisions. Ibanez held that a mortgagee needs to have a mortgage assignment at the time of foreclosure. The failure to do so makes the underlying foreclosure void. The result of that was that thousands of foreclosures that had already occurred were now invalid. And the real problem came for those who purchased these foreclosure properties after the foreclosure had occurred. The result of that was that the new owners had bad title. They really couldn't sell their properties, and many title insurance companies, lenders, buyers and sellers became very concerned about this growing problem, and that was the reason for this foreclosure title bill. The bill had been raised a couple of years ago and had been signed by Governor Patrick, who asked for a 10-year deadline for challenging foreclosure, which the legislature didn't agree to. This time it did pass with a much shortened deadline. Under the bill, the Massachusetts bill now imposes a 3-year deadline for challenging a foreclosure. This deadline starts from the date that the affidavit of sale is recorded in the land records. The affidavit of sale is almost always recorded with a foreclosure deed, which is generally recorded at least a couple of months after the foreclosure sale itself occurs. Once that affidavit of sale is recorded, the homeowner has 3 years from that date to go ahead and raise a challenge to the foreclosure. For foreclosures that had occurred over 3 years ago, these homeowners now get an extra year after the effective date to go ahead and challenge a foreclosure. This bill recognizes that foreclosures can be challenged in 2 ways. First, on the offense, which is by filing a lawsuit against the bank, generally in Superior or Land Court, or on the defense, which is where a homeowner can challenge a foreclosure that's been brought in an eviction proceeding. The bill recognizes that either one of those are means of challenging a foreclosure. Under this law, a homeowner who brings one of these challenges, either on the offense or defense, has to record a copy of this pleading in the land records. The bill specifically requires each registry of deeds to accept these for recording. So a homeowner who brings one of these challenges simply has to take it to the registry of deeds and have it recorded in order to satisfy this requirement and to meet this deadline. Take-home lesson from this foreclosure clearing bill is that homeowners need to act soon in challenging a foreclosure. I've always said that sooner is always better in challenging a foreclosure and trying to deal with one of these problems. And this foreclosure clearing bill is now another important reason why, because now there is a real deadline in place, and the failure to make it means that a homeowner can be completely out of options. Thank you so much for listening to my presentation. This again is Adam Sherwin of the Sherwin Law Firm. My website is www.sherwinlawfirm.com. My website has many foreclosure defense resources that are available. I hope you check it out. If you have any questions or you'd be interested in a consultation, feel free to reach out to me. Thanks so much for listening.